So, welcome to estate planning. So I'm Cory Cottam. I'm in the second ward. I'm an attorney. I do estate planning, business planning, stuff like that. So Brother Pratt from the 9th ward reached out and asked if I would do a presentation on basic estate planning. So that's what we'll be discussing today is basic estate planning. We'll talk a little bit about advanced estate planning, but just kind of the basics. We'll talk a little bit about the things that would be necessary for emergency response. When I was sitting out here, and I don't know if the person's in here, but they said, well, what does estate planning have to do with emergency preparedness? And I kind of thought the same thing when Pete reached out. But then I started thinking, well, I deal with lots of clients who have an emergency and they're in the hospital and they're incapacitated. They're not dead, but they're incapacitated and they can't make those decisions. So that's all part of estate planning. So what I want to do is start, if everybody got a notebook, I'm just going to have you write down just a quick little quiz, some questions. Just write down your answer. You don't have to share these or anything. But the first question is, do you have minor children? The second question, do you have adult children? Do you have a spouse? Do you have any living family? Do you own a home? Or do you rent? Do you own any of the items inside your home, whether you own it or rent or you're buying? Do you own anything that's inside of it? And then finally, is your heart beating today and are you breathing? So if you answered yes to any of those questions, you need some level of an estate plan in place now. So the next set of questions, these aren't just yes or no, these will be things you write down. And if you're with your spouse, when we talk about income, it's not annual income, it's individual income. So write down your annual income. Just your individual, how much you make. Whether it's Social Security, whether it's employment, whatever it is, write that down. And then next to that number, write down how much life insurance you currently have in place. If you have minor children, I want you to write down the person that you have spoken with to be their guardian in the event of incapacitation or death of yourself. And then next to that, write down where in your home that document can be found today. If you have adult children, write down where in your home you have a list of your tangible assets, tangible meaning anything you can touch and grab, tangible assets, and who should get each thing upon your passing. Again, if your heart is beating today, right now, write down the person you have given written authorization to make healthcare decisions in the event of an emergency. And then finally, if your heart is beating today, right now, write down the person you have given written authorization to make day-to-day decisions should an emergency arise, such as banking decisions, real estate decisions, any decisions that would need to be made. Sorry, I had one where I said finally on the last one. But write down where in your home an individual would find vehicle titles, insurance policies, list of debts, mortgage information, other pertinent financial information like investments, contact information, stuff like that. Where in your home would somebody find that today?
Can you repeat those?
Yeah, so where vehicle titles, mortgage documents, deeds to property, life insurance policies, any other financial investments that you might have. Okay. So we'll go back to the first one. Write down your annual income, and next to that, write down how much life insurance you have. If the number on the, if your second number isn't more than 5 times the first number, you need to get in contact, and somebody relies on your income, you need to probably contact somebody about upping your life insurance amount. When I initially was introduced to this, it was said if you're the main breadwinner, you're the sole provider. So in my situation, I should be insured for 5 times my annual income in case anything happens. Adri would be okay. Adri's my wife. However, I got thinking, like, what if something happened to Adri, and now I need to hire somebody to watch my kids every day, and I need to watch them, somebody run them around, this and that. So I have applied it to both spouses. Each spouse should be insured to cover that.
What if you have no dependents?
If you have no dependents, if nobody relies on your income, then life insurance, you don't need to worry about that.
What do you do when you're old and don't life insurance? More than you make.
Then you should have came to this class 20 years ago. And we could have done, got you set up with some term life insurance. But yeah, I mean, people run into that where they're not insured at that high at that time in their life, and it is hard to get. It's really expensive.
Would funeral costs be paid with life insurance generally?
What was that?
Funeral costs,
Mm-hmm.
dependents.
Yeah.
Would you still have life insurance costs you to pay for the funeral?
Yeah, at minimum. So funerals are $10,000 to $15,000. So you should. A lot of, like, I know with my banking institutions, they offer that as a benefit. You just have to sign up for it. I think it caps like 2, but I mean most people. Well, we have like 3 or 4 bank accounts who are signed up on all of them, and so between that we cover. Yeah, you definitely want to cover funeral costs, and we'll chat about that a little bit too. Okay, so then we were talking about if you have a minor child, so those of you with minor children, if you have not designated a guardian for that minor child should something happen, who knows like what happens in that situation? Yeah, somebody has to make that decision. And in my experience in dealing with this, both as an attorney and just in life, as soon as there's $1 to be had, and I say that just because this is my experience, as soon as there's $1 to be had by that guardian, everybody has the child's best interest in mind, whether they do or not. So, I've seen this where mom and dad have both died in an accident. There's nothing directing it, and suddenly every sibling on every side, and you end up in court, and it can get messy. I'm not saying every situation does, but it does. It can. So you can control that by doing that in your healthcare directive. You can appoint who that guardian should be, should anything happen. So you can help resolve that.
Quick question. My ex and I were in the Air Force, and I got pregnant, and so we went into the Air Force office, and we made a will and designated a guardian if anything happened to us. I was 21 years ago. We had 6 kids. At the time I was pregnant with my first, and my oldest is now 21 and does not play him anymore. So do I need to completely redo that, or?
So it'd still apply to your other minor children. If you want a different person, then you would need to redo it. Yeah. The other thing is, so the next one was your tangible assets. A lot of times when I sit down and I meet with people, they're like, oh, my kids aren't going to fight. They all get along. until the same person wants mom's wedding ring. Or the same person wants dad's hunting rifle. Or great-grandpa's hunting rifle. So if you don't have a list, and it doesn't need to be everything in your home, but the things that people care about, heirlooms, whatever it might be, have that written down, and we'll talk about that too, just to help your children or your heirs not have to deal with that fighting.
Well, last year, I said, okay, I'm going to start, I'm sending you all these pictures, and if anybody wants any of these, I want you to take them. but they sure didn't take as much as I wanted them to. You know, and so my kids always say, well, Mom, put something on there saying, this is very important to go down through the people and keep it, don't give it rid of it.
Yeah. Yeah, so,
maybe you realize you have way too much stuff, so you start downsizing.
so a lot of people, some of the easiest estate stuff that I've helped wrap up the estate on, that's exactly what's happened, is they've said, come in, you know, take what you want now, and then we don't have to worry about it.
Yeah, take it.
Yeah, take it now.
Leave it. Well, I'll get it later, Grandma. Just put it in a box with my name on it. And I
Yeah.
said, that's not what
Nope.
I wanted.
I want it out of my house. The other thing is, I'll tell people that too, is when you get to where you're not using those items, and this is just personal advice, this isn't legal advice, I just tell people, like I've told my parents, like, I would rather than leave us money, like, take us on a trip. Like, watch us enjoy that, watch your grandchildren enjoy that. It's not for everybody, but it is a conversation that I have frequently with clients.
Because they're not going to teach what you think I got this little thing that looks like a corn, and it says made of glass, and I just love it. But that doesn't mean that they're going to like it. So
Yeah.
you're right. Figure out what everything's worth and then just give everybody money.
Yeah. Or my mom just sends it home with her grandkids and makes us take it to the eye if nobody wants it. And she's open about that. So, written authorization for healthcare decisions. I do have these here today if you want to fill this out. If you don't have a healthcare directive, I have copies up here. You can fill them out. Adri's here. She's my notary. And I also, we'll talk about power of attorneys as well. I have some of those. So healthcare directive and power of attorney are not the same. They're not the same document. In Utah, there's a healthcare power of attorney or a Utah Advanced Healthcare Directive. This is for healthcare only. This appoints people to make healthcare decisions for you. But it also, you make those decisions in advance on here. You decide, like DNR or anything like that. You make those decisions, but then you also appoint somebody to make sure those decisions are executed. So I have those up here. When we're done, if you want to take time and fill that out, you can do that. The reason why that's important, the reason why it's important is if something happens, you go to the hospital and there's nothing on record, nobody actually has that legal authorization to make those decisions.
Does everything need to get notarized, or what happens if you don't?
So the Utah Advanced Healthcare Directive does not require a notarization. In my office, we notarize everything just because it's an extra layer of protection. But the statute for the Utah Advanced Healthcare Directive doesn't require it because the state wants us to have this document. They want these in place so that something happens, physicians, nurses aren't left with trying to figure it out. So that particular document can be modified just by crossing out and writing through it. Other legal documents you have to do a formal amendment to, but the Advanced Healthcare Directive, you can just cross things out and change it as you go.
Is anything invalid without a notarization?
So if it, like a regular power of attorney requires notarization, trust, will, things like that all require it. The only one that doesn't require it by statute is the Advanced Healthcare Directive.
Is there some kind of document or something that like says your final wishes, how you wish to be disposed of?
So like funeral plan type things?
Right.
Yeah, so that would be in your will, which we'll get to in the will. Typically there's a funeral directive in there. The most common thing that I see in Utah is to burial rights by the traditions of the Church of Jesus Christ of Latter-day Saints and not to exceed an unreasonable amount. But I have clients that direct to be cremated and what they want done after that. But yeah, that can all be put in the will. Okay.
Sorry.
Yeah.
Can a person just write those things, call it their will, write it down, and go get it notarized?
Yep. So we'll just jump to that.
Sorry.
Let's do power of attorney, then we'll jump to there. So power of attorney is the other side of the healthcare directive. That's the other document that I brought and provided today. That allowed you appoint an agent to be over your day-to-day decisions should you become incapacitated. Power of attorney ceases upon death. So you can't just have a power of attorney to take care of things after you die. The power of attorney allows people and you appoint what powers they have. There's a checkbox here for which powers you want this person to have. This is a good form. This is a statutory form. It's available on the court website. It's a general basic thing. If you go in and meet with an attorney, they'll go through and will specifically say, like, real estate powers. They can buy and sell property under my name or property owned by me, where this will just say real estate. Title companies want something a little bit broader to transfer property. So, okay, so we'll jump to wills. So the foundational part of an estate plan is a will. Most people, well, all people should have a will. A will has to be probated. It has to go to probate. And when I say probate, a lot of people are like, oh my gosh, my stuff's going to wind up in the courts forever. 90% of probate cases are super smooth. We open it, we get a personal representative appointed. That person is appointed powers by the court, and then they can do all these things. As long as it's not contested, it's pretty smooth. That's the advantage to having a will, is you get to appoint who that person is. So you ask the question, can somebody just write all this down, have it notarized? In Utah, yes, it's called a holographic will. And that's just where you write down your wishes, you sign it. It needs to be signed or witnessed by 2 people who are disinterested parties. So your children couldn't witness you signing it. Has to be 2 people that would not take from the will. And then have it notarized and put away. It would still have to go to probate. The court would still have to see it. In a situation with a holographic will, some judges will want somebody to come in and testify that they knew that it was that person's handwriting. That's typically in smaller towns. Up here, if we attach a holographic will to a probate, we just can get the letters. Yeah.
Okay, I've been told that my son made a trust for me, a living trust or whatever you call that. But my daughters feel we should change it around because some things need to be changed. But a trust is better than a will, or you need both.
Yep, and we're going to progress up to talking about a trust. Yeah.
Yeah, on the will, when it goes through probate, about how long does that take?
So you can't file probate till 10 days after the person's deceased. Once you file it, if everybody agrees, you can just waive, and you can be appointed within 3 to 5 days. And then just how long does it take the personal representative to wind up the estate, sell property, distribute things, and then everything that gets distributed gets accounted for and it gets filed with the court. So you're appointed usually within 3 weeks, and then the actual probate process, it just depends on how I have some probate cases open right now that we've been open for 2 or 3 years, just distributing assets. But some are fairly quick, like there's not large. And a side note on probate, if you don't own any real property and your estate's worth less than $75,000, it's just an affidavit you file with the court. You don't have to do a formal probate. So with the will, oh, yeah.
Real quick, back to the written authorization of the power of attorney. Is that just something you keep in your important documents that they can access, or does it have to be filed somewhere?
Nope, it doesn't have to be filed. It's just inside, like this is our trust binder, so ours are just inside here. And then we've just let the people know who our successor trustees are, where this is at in our home, how to get into it, and then all the documents are in here. So some people will give the person that paperwork so they already have it. It's up to you. It's a personal decision. So jumping back to the will, a will, like I said, that's like the baseline. You should just have a will appointing somebody to take care of your stuff. Even if your estate falls under that affidavit threshold, you should still have somebody appointed to just do that for you, just so there's no fighting. Within the will, you can appoint the guardian for minor children. You do funeral directives and anything else like that. So it can be handled with the will, but it's going to become public record once it's filed with the court. And that's, a lot of people want to avoid having that stuff become public record. Any other questions on just a basic will? So a will can be notarized or handwritten. You can type it up. within the will, and then you just need 2 disinterested people to witness it, and it needs to be notarized to be valid. So the next step up from that is a trust, just a basic revocable trust, and that's what we'll chat about today. There's other types of trusts. That's kind of outside the scope of today. If we're doing like asset protection stuff, I manage a trust that within the trust we have multiple LLCs because of asset protection type stuff. We won't get into that. So a basic revocable trust, that is where you're basically creating an entity. I brought ours just so I can have something to hold up. So this is our trust agreement. Basically, we've created this entity out here. It doesn't get registered. It doesn't go to the court and get registered. There's no like registry of trusts or anything like that. It's a personal document. But within this trust, right now, Adrian and I are the trustees of our own trust, meaning we have total powers over the trust. Our home is owned by our trust, which means we can sell. We don't have to get permission from anybody, anything like that. Your trust, typically when you create a trust, you're going to transfer your property into the trust to you as the trustee, but it's owned by the trust. The advantage to that is now you're outside of probate, because to transfer real property, you have to have powers either through probate or by a trust. So my typical threshold for somebody to need a trust is if you own real property. If you own a home, land of any type, doing a trust, there's value there because everything's going to pour there. When you pass away, your successor trustees immediately have that power to market your home, sell your property, things like that. They don't have to be appointed by the court because you're appointing them, you're giving them those powers within the trust document.
And this is a revocable trust?
Revocable.
Okay.
Revocable meaning that you maintain the powers to amend it as life goes on. So, for example, we did ours like in 2014, 2015. All of our children were minors at the time, so there were certain things that we had, stipulations for them to take. Once they start becoming adults, we've removed some of those things. So, but you can amend it. Revocable basically means you can revoke it or make changes to it as life goes on. I'll touch on irrevocable briefly. Irrevocable is where you give up all of your rights to the things transferred in there. It's the baseline for asset protection. So Sister Bauer had asked about, going, sorry if I, like if somebody needs to go into a nursing home, but we want like VA benefits to help pay for that and not have to sell our assets. The baseline would be do like an irrevocable trust where you would remain the beneficiary, meaning you get the benefit of everything in the trust, but you're not the trustee. You don't have powers to sell or do anything like that. You'd have to have your trustee do all that stuff for you. And in an irrevocable, you can't be the trustee and the beneficiary. So that's kind of the baseline of asset protection type stuff. Any specific questions on a trust versus a will? Yeah.
Is it expensive?
Do you want me to kill my business? So, it depends. Like, that's the typical attorney answer, right? It depends. A basic baseline trust for a married, if we're doing, well, I'll start with like an entire estate package, like if you're doing a trust, a will, power of attorney, healthcare directive, I'm taking care of all the transfers of all properties, covering those fees and stuff, it's about $2,000 to do something like that. And I'm really not here to plug my business, but when I've done like market research to see where I'm at, I am on the low end because I got my pricing from attorneys in a rural town, and when I moved here, I just kept that pricing, and so but it just depends on what you need and what you want. Yeah.
If you do one of those and then you sell your house and buy a new house, do you have to redo all those fees again?
Nope. So if you do that, you're going to transfer the home into your trust. When you go to sell it, the title company will make you transfer it back to you as an individual to sell it. But then when you buy a new one, the title company will generally just prepare that deed for you to put it right back in your trust. Because in the trust, it just references the marital home or the home then living in. And so it doesn't, you can sell it, you don't have to make amendments. Yeah.
Do you go through a title company to put it in the trust or take it out of the trust?
So I do that, like, if I'm preparing a trust for a client, I just prepare that transfer deed, take care of recording it with the county. If you go to sell it, the title company takes care of it for you, it's just part of their.
Probably a little fee each time you need to do that.
So the recording fee, just statewide, recording fee is $40 to transfer it into the trust. If I'm doing it as part of an estate plan, it's just all included in there, taking care of that. If somebody comes to me, so that's the other thing, while you brought that up, a lot of times people will do a trust, but then they don't do what's called funding the trust. A trust has to own something to be valid. It can be just a bank account with $5 in it, and it's good. But transferring your home in there, that's what we're trying to do, right? Avoid probate. A lot of attorneys or people that prepare trusts, because you don't have to be an attorney to do a trust. What they do is they prepare it and then they tell the client, okay, now go transfer your home. And that's where it stops. I've got one, I'm doing a probate in Santa Quin, a double probate down there, where they had a trust, they had everything put together, but they never transferred the home. So now we have to go through probate to be appointed to transfer the home. So they everything else is set up, but they didn't avoid probate. But yeah. Did I answer your question?
Yeah.
Okay.
Yeah.
I have one.
Yeah.
Some years ago, we bought a product for long-term care, and now we were informed a few years ago that our state has passed some kind of law where if you need long-term care, and that's supposed to be provided, we're supposed to have paid into that with when we were working, but anyway, laws have changed, and now the state can take our property so that we have nothing to pass on to our children. I'm not explaining that very well, but you know what I'm talking about. Okay. So.
Yeah, and that's something. So, like, when I do things like this, I just have to be careful because my malpractice would kill me if I was giving general advice on something like that.
Sorry.
But no, basically, there's still ways to avoid that. I know the law that you're referencing for long-term care, a lot of it has to do with look-back periods and things like that.
With what?
Look-back periods of when things were transferred.
Right.
Like Medicaid has a 5-year look-back, so if you transferred something today, really the protections don't take effect till 5 years down the road because there's all this back.
Don't have to go into care for 5 years.
Yeah.
Tell your kids they have to take care of you.
Yeah.
Okay.
Yeah.
If you have long-term health insurance, it's not valid in Utah or something, or what's?
No.
Okay.
No.
We
I think what
don't
you're talking about
long-term.
is, you're talking about a long-term care policy to take care of you if you were in a facility
Yes.
to pay for the facility.
Okay,
Not
so that's-
like, that's different than a long-term health insurance or a long-term disability insurance. That's gonna be something different. I can see you have questions, so we'll chat after.
Yeah, I don't quite,
Yeah.
because I do have long-term health, so I
Mhm.
think Medicare is like 90 days, and this will take care of you for like 3 years or
Yeah.
something. That's still valid?
Yeah, that kind of stuff. Because she's talking about a long-term care facility plan that would pay for like,
Oh,
I don't know, like legacy. I don't know what they're called. Heirloom Inn is where my
Yeah.
grandpa was. So.
okay, I get it then. Thank you.
Okay. Other questions about the trust, things like that.
This is a quick little question.
Yeah.
So, okay, I get the probate one. So with a trust, as long as your children or whoever know who that was through, then say it was you, they just come to you, and then what does that look like from their perspective?
Okay. So, like, if you have a trust and it's done through me, you have the trust binder. Mine's sitting in a safe in our house. Successor trustee knows where it's at. They can go and get it. They never even have to contact me if they don't want to. They can contact me for help. Usually what people will do is say, you prepared this, can we have a meeting? They come in, we meet for like an hour, we go through it, we talk about intentions, things like that, and then I explain the person's powers to them, and a lot of times I never see them again after that appointment. Because if it's well planned out and everything's in here, they just don't need me because there's nothing for me to step. That's why you've done the trust, is so that they can take care of it. If they don't, and we have to go through probate, then they hire an attorney, goes and represents them at court, and there's a much more hands-on process because you're exchanging documents and stuff. It's still not. Probate, I don't want to make people feel like probate's scary, because it's really not. It's just, it has that. It can be, like, you know, but generally speaking, it's not.
You also made a statement about something becomes public record and they don't want that.
So, yeah, so
What does
your,
that mean
so
exactly?
your will, like, if you were to pass away and you just had a will and we filed it with the court, your personal representative then gets to sell your home, sell your assets, but there's an accounting sheet that accounts for all that stuff. Like if you have a side-by-side or four-wheelers, it's all listed, who got it, or if it was sold, how much it was sold for. That document gets filed with the court and becomes public record. That's what people generally don't want their stuff out there. And so when I say they, it's just a personal thing.
So how are you informed if a client of yours passes away? How are you informed? And what if somebody didn't know that they had something? How do
Yeah.
they get it?
So I only get informed if they find the trust binder, or because my contact information is in the trust itself.
Uh-huh.
So perfect example, if somebody has something and you don't know, right out of, this was like my first case out of law school. I was a gentleman down in Price. He had passed away. He had no family in this area. His only living heir was a niece, and she lived in Marion, Indiana. She just contacted an attorney out here and said, hey, my uncle passed away. What do I do? And so we got talking. We opened a probate because we couldn't find it. There's nobody to go find documents or anything. So we appointed a probate, because you can't get in the house if you don't have a key, right? And the locksmith isn't going to just let anybody in. They want to see those letters. So we had a personal representative appointed. We actually had her appointed, and then she transferred power of attorney to me to act on her behalf so I could go to the home and things like that. Looked through the home, no trust, no will, but we found a safe deposit box key. So I took the safe deposit box key down to Zion's Bank, and no owner other than the individual who had passed away. So the probate allowed us to do that. We opened the safe deposit box, and there's a trust and a will inside the safe deposit box. So that was one of my tips at the end, is once you have your documents, put them in a safe place, but make sure people know where they're at. Make sure people know that they're there. And if it is in a safe deposit box, make sure that your successor is a co-owner of that safe deposit box so they can go in. Because we had to do that, and then we had to pay someone to come and drill the safe deposit box open.
Oh, wow.
And so, like, we were into this, I don't know if you even remember, a few $1,000s just to find out we didn't have to do all of that. But, so yeah, make sure somebody knows that your estate plan's done, where it's at. I suggest talk to your successor trustee or your personal representative, just so that they're aware. Make sure things are in line. Yeah.
How much is probate? Go through that system.
If it's a very simple probate, it's about $1,500. Attorney fees run between $700 and $1,000. Filing fee with the court is $375, and you have to publish death on the statewide website and the local newspaper. That runs about $300 for the publication. If it gets contested, most attorneys do it on an hourly fee after that. But yeah, if it gets, yeah, we'll leave it at that.
Money either way.
Yeah.
I was gonna say an example of that, 20 years ago, my dad and mom were in a car wreck, my dad was killed, they lived in Provo, and my mom was incapacitated, and, my dad had told me once where a key was in a book several years before. I couldn't remember any of this, I looked through all his books, everything, I mean, it took some time just to figure out where everything, was, and he had it, kind of organized, but, so just don't depend on saying it once to your kid.
Yeah.
It's kind of
In
haphazard,
passing.
you're not, this makes the statement, oh, you're never gonna die,
Yeah.
We found a box finally hidden down in the basement, and it just, it was a heavy, thick box about that big, and it just shook and it rattled, and we're thinking, oh, this is where all the gold is, We couldn't find the key for it, and so finally I had to chop it open, and there was all my dad's keys he'd ever had since he was a kid, you know? And so you just don't depend on telling your kid or whoever once, because like I couldn't remember it. It was quite a process trying to figure out everything that happened.
Yeah, and as time goes on, that's a conversation to continue to have. And if you're younger when you do it, so like if Brother Stevens gets his all arranged, happen, it's an ongoing conversation. I typically recommend after you have it done, just to review it every year, every 2 years, just to make sure things are up to date. Typically, like with my firm, if we do your initial estate plan, when you come in, if you need an amendment done, those first amendments or two we don't charge for unless it's substantial, like filing fees, if we're transferring property, stuff like that. So yeah, amendments to a trust they have to be formally done. You can't just write. You can't just cross things out. It's not valid unless it's a formal amendment. Any other?
Oh, you
Yeah.
mean, say, someone else's name was on there, you're not married to that person anymore, so we have to create a whole new paper?
So you wouldn't have to. If somebody dies, like if your spouse dies, you still maintain all the powers. You don't have to change it. If you get remarried and you want that person on there, you don't have to redo everything. You just do an amendment, and it just says that I'm appointing so and so as my
son
trustee.
Had been interested in things he knows, so he made this up. I mean, that made it, you know what I'm saying? He wrote it up, and but my daughter's one that lives here says I think we need to change it so that I'm here can actually be right on top of whatever needs to be done. So that's what we're going to do. And so if I put her name in, how much, what are you doing with that name? I mean, what can they do for you?
So if you're making them your successor trustee, so you're talking about swapping them out for your son?
I guess.
So you're just giving them any powers that are disclosed in the trust or appointed within the trust?
I'd like to just do them all three. Then, all three names on there. Because that's what I would like to do. And order doesn't matter.
Yeah, and a lot of people will do that. They'll put all their children. I don't recommend it, but some people will put like all three and give them equal powers so they can act individually.
Maybe that's worse, right?
Yeah, because you're not avoiding conflict.
Two girls against the boy.
Yeah. So some people will appoint them one person with the power to grant powers. So like in my family, if it's Cody, she can do it, but if she needs help, she can grant the power to Dagan. But Dagan doesn't just get the power without Cody's okay.
My daughter that's here, every time her sister comes, we never get time enough to do it.
Yeah.
And the son, they're not all three together, they're running one.
Yeah, not everybody has to be together to do it. You can just take care of it.
I did one a few years ago and had all my kids play a board game. And the winner gets to be the trustee.
You should make the loser be the trustee. Sister Bauer.
If they have property that happens to be appraised, right?
What's that?
If they have property that has to be appraised for final probate.
Yeah, for final probate, it needs to be fair market value or otherwise agreed upon.
So you have to pay for an appraisal and everything, but
Yeah.
I just wanted to, test going through with my parents, and they had a will, and then my mom died, and then my dad remarried. It's a different situation when you have something coming in, or someone else coming in to and you need to prepare for that. And I think also is that if you want to make it where your kids get along better, you become the bad guy and you tell them how you want it to be. You're causing problems if you leave it to them to decide between themselves, unless they're unusual,
Yeah.
I mean, that's pretty blank.
Yeah, and I've seen I've seen it from here to here. I'll share one other horror story and then give some tips and tricks on this. I came into a case as a mediator, was that in 2016? 2016-ish. I was hired on to mediate a probate case. This probate had been open since 1999. The initial value of the estate was $52 million, and when I got involved in 2016, it was $700,000, and everything had gone to attorney fees because they just kept fighting and going back to court. Finally, after that, I mean, the money's gone at that point, but the judge finally said no more attorney fees. But you know, at that point, they had just fought, and it was, both sides were, I'd rather see it all go away before the other person gets a dime. And then all that money, and I was like, I don't want to be you on the other side. I mean, there's horror stories, but I do a lot of cases where it's just in and out, and we're done in like 4 months. So, final tips and tricks, and then those of you, if you want to take the time to fill out a power of attorney, healthcare directive, Adri's here, she can notarize the power of attorney. Healthcare doesn't have to be notarized, so you can just take it with you. But if you want the power of attorney, you'll just take a minute, fill it out, and Adri will, if you have your ID, she will notarize, right? She'll notarize for you. Yeah.
Cory, can I just suggest something too? I went through my DNR with my doctor, and she told me how to fill it out, and then she added some things so that I could, you know, I mean, you just don't want to say, no, I don't want to have any life-saving things, because there's just different situations. And I just felt more comfortable with doing that.
So what most people do, I will say, so on the healthcare directive, on the page 3, it'll give you options, and most people that I work with choose the one that says, I choose to let my agent decide, option 1. It says, I have chosen my agent carefully. I've talked with my agent about my healthcare wishes. I trust my agent to make the healthcare decisions for me that I would make under the circumstances. And that's why, is because there's different circumstances, but if you've had that open and honest conversation, then your agent's going to know what your wishes would be.
Is it good to have your spouse do it, or a child, or somebody?
Most people have your spouse act while they're living and able to act, and then whoever you trust to do that. Like my parents, I'm in charge of their estate, but my heartless brother's in charge of their healthcare, because he'll pull the plug and I'll be like, no, they're staying. So it just depends on who.
That's true. When my dad died, he wanted to go, but my sister couldn't let him go.
Yeah.
So it was up to us, and so we honored her wishes for a while. You know,
Yeah.
but it was hard on me.
Is there one over? So just kind of wrap up before we do that. I just wanted to go over some tips, and these are just, this isn't legal, anything, this is just the way that when people bring me stuff and it's set up and it's nice flow. So this is just our example. So inside our trust binder, we have trust instructions. This just comes with your trust. Like, what do you do with each kind of asset? And it lists the most common assets, like bank accounts, real property, brokerage accounts, trusts, like what to do with it. So that's always inside of it. We have active debit cards for our trust account, so that if something were to happen, our successor trustee needed to access funds, they don't have to wait for life insurance policies. They have active debit cards, so they can just go out and immediately start taking care of things. So we have that. We have the trust. Oh, I do have to bounce back. Even with the trust, you do have a will. It's called a pour-over will. All it does is leave everything to the trust. Then if there was something contested and you had to do probate even with the trust, the only thing that becomes public record is the pour-over will. So we have the healthcare directive, and then back here, it's just good to have, whoops, copy, like we just have the titles to all of our vehicles, toys and stuff like that, just all put in here so that the person doesn't have to do, go to the DMV and worry about it. Everything's here. Cars, we don't transfer to the trust just because they're liquid. We buy and sell cars all the time, but we do keep the titles here. If anything were to happen, the person just has to literally come to this binder. Our life insurance policies are in here so that they can just go right to one place. We have a list of active debts in here, mortgages, things like that, just so that they're aware when mom and dad pass, everything's here. And we try and keep this updated. And then I have the power of attorneys for my adult children because I'm a nerd. And then we just keep cash enough so that if something were to happen, if it was an emergency, banking stuff was down, we have a small emergency fund, just some cash in our binder. Just for that, if we're talking emergencies today, if it was an earthquake, ATMs were down and they needed access to some immediate cash, there's always some there for them. That's just basic advice, not legally, it's just since it's an emergency preparedness thing, I like the idea if anything were to happen, they just have to grab this binder and everything is there, access to accounts, as well as having a little bit of liquid that they can take care of things.
Do you put birth certificates in there too?
So you can. Adrian and I are a little bit. We have a folder for each of our kids with all that stuff that sits with this, but it's not within the binder. Just because, like, as our adult kids get older, then they can just grab that and take it with them. But yeah, it would be a good place to have any identifying information.